Tonight on Nation to Nation, a chief from one of the 21 Robinson Huron Treaty First Nations gives us an update on a $10 billion settlement.
We're hoping to have a finalized agreement by the new year or shortly thereafter.
A small First Nation in British Columbia continues to lose court battles over its failure to accept eligible people as band members.
Council has been held to or found to have abused their powers in bad faith.
British Columbia First Nations are betting on the liquefied natural gas industry for economic and environmental benefits.
The Haisla and the Niska are very concerned about how they can develop these projects in a way that does help to mitigate climate change.
Anine, welcome to Nation. I'm Annette Francis. An 1850 treaty will soon be upgraded, and it will mean $10 billion for 21 Ontario First Nations. The Robinson Huron Treaty stretches from Parry Sound to Sudbury and North Bay to Sault Ste. Marie, along the shores of Lake Huron. Annuities to the First Nations were supposed to increase as resource revenues increased. However, the annuity remained at $4 since 1874. Chief Scott McLeod is from Nipissing First Nation. He joins me now. Welcome, Chief McLeod.
Hi, good to be here, Annette.
All 21 First Nations have signed on to the agreement, but there were some disagreements from some First Nations about how the money would be divided. How has that issue been settled?
Well, I think after some lengthy discussions, it was apparent that the concerns that some of the First Nations had were really not had nothing to do with the federal or provincial government and the overall settlement agreement. So basically, we agreed to have these discussions afterwards and get the settlement finalized. Otherwise there would be no settlement to talk about. So we will continue to have discussions about the disbursement agreement, which is between the First Nations. But we have to get over the goal line before we have those discussions. As I said, if we don't, there will be no discussions on disbursement if there's nothing to talk about.
As it is now, how would the money be dispersed, and what will that mean for communities?
Well, there was a formula that was agreed to back in 2012, which had an equity piece built into it. So some of the smaller First Nations with less capacity would receive a bit more per capita to alleviate some of those capacity gaps. And the thing was, back in 2012, we had no idea how much money was going to be on the table. And then once that settlement came, then there was the concerns went back to that disbursement agreement. So it's a very complex disbursement agreement, and I don't think there's any silver bullet on having a disbursement agreement that would be completely 100% fair in any of the First Nations. So what we try to do is work to find the best solution for all of us, and go on consensus. So and what that means to our communities is essentially how much the community receives at the end of the day. And but once that money is received, then it's up to the First Nations individually and independently to determine how that community money will be used.
So community consultations are now taking place with members. How many sessions are there, and what are you hearing?
So it varies, because we have 21 First Nations, and really the public consultations are up to the individual First Nations. Nipissing, where, my community, we're now we've finished 8 consultation meetings with our community. Some have just begun, but really it depends on how each First Nation wishes to handle their consultation process, which is not governed by the litigation management committee or by the courts or by anybody other than the respective First Nations. So it's really the onus is on all of us as leadership in each of our communities to determine how that process is going to look. And some of us have, jumped out right from the starting gate and got a lot of the consultations done, and are preparing well in advance of receiving any of the compensation funds, and some have just begun. So it really depends which First Nation you look at to see where they're at.
How close are you to signing the agreement?
Well, I mean, the agreement is already signed on our part. The province and the federal government are committed to sign. There have been some glitches in the process that have pushed things back. We're originally looking at a November signing, but that's been pushed back because of some of the disagreements, but those are out of the way. So we're hoping to have a finalized agreement by the new year or shortly thereafter, which will set in process the 60-day period for monies to start flowing to the trust, and then from there going to the communities as per the distribution agreement.
Earlier this month, the Supreme Court heard from the province of Ontario regarding annuities. What could this mean for future compensation?
Well, I think it sets the stage for future compensations for past, such as the Superior, but also it sets the stage for the go forward in the Robinson Huron. Now that we've reached a compensation, we've seen in the courts that litigation, Canada and Ontario basically lost the decisions quite heavily in our favor. So I think that says a lot to how the process will occur as we go forward for the treaty payments into the future, because none of the evidence and none of the testimonies and rulings will change. It's all the same evidence being put forth. So to me, and I'm no legal expert, but we've won this case, and if we're using the same evidence and the same testimony and research moving forward, then that would likely mean that the decisions will be in our favor again moving forward. So I'm hoping, and most of all leadership is hoping that the go forward will be settled in a negotiation process and not in a litigation process.
Okay, Miigwech, thank you for joining us.
Thank you very much for having me this morning.
Stay tuned. The Peters First Nation has had a long battle in the courts for all the wrong reasons. That's after the break. Welcome back. Over the years, APTN has covered a few stories on the membership mess on the Peters First Nation. It's a small community in the Fraser Valley just east of Vancouver. It has a custom membership code. Many say it is unfairly keeping people off the membership list. They are recognized as status by the federal government, but not as community members by Chief and Council. The Peters First Nation has been challenged many times for its discrimination and breach of fiduciary duty at the Canadian Human Rights Tribunal, Supreme Court of British Columbia, and at the Court of Appeal. David Wu is a lawyer who represented non-members who took their case to the Human Rights Tribunal and just won. Joining me now is David Wu. Welcome to Nation to Nation.
Thanks for having me.
Can you give us an overview of the most recent human rights case and what it means?
Yeah, so this is a case in which five complainants sued the Peters First Nation in the Canadian Human Rights Tribunal, and it's about how the Peters Nation have denied them membership or have processed their membership applications in discriminatory ways. And the tribunal, in a decision released yesterday, agreed, at least for four of the five complainants, that was the case.
How many times over the years has Peters First Nation been taken to court over discriminatory policies and membership applications?
Well, this is the first one I'm aware of in which the Canadian Human Rights Tribunal has weighed in. There are, I think, 3 federal court decisions, 2 federal court of appeal decisions in relation to membership issues for other people, and also leave to the Supreme Court of Canada decision on that. All of which Peters Nation was unsuccessful.
You also represented members who sued the band for breaching its fiduciary duty. You've won that too. In fact, the British Columbia Court of Appeal just recently upheld punitive damages against council members. Can you tell us more about that case?
Yeah, so that case was not in the membership context, but in the fiduciary duty context. And that case was all about how council was improperly self-dealing. They were, for example, employing themselves in staff positions and deciding on their own remuneration, not following their own conflict of interest bylaws, and deciding, paying themselves ad hoc amounts for meetings. So there's a number of issues with how band council were dealing with band funds throughout the years, which was the genesis of that trial.
Why does the council keep rejecting people, and how do they keep getting elected?
That's a great question. I mean, there's been many findings of bad faith now, including this most recent tribunal decision, in which council has been held to or found to have abused their powers in bad faith, and so what they've done is not contemplated in their membership code at all. It's simply seems like up to their discretion, and how they keep getting elected is I think just the unfortunate reality of small First Nations, which might have kind of entrenched divisions, and where everyone is related. A lot of people in the band are related to the council members. That those relations might trump findings by the court that they've acted in bad faith, and thus they keep getting elected.
How does this keep happening? Should the federal government step in to stop the ongoing series of legal fights from happening?
Yeah, that's a great question. I mean, the role of the federal government is an interesting one, and what they should be doing to remedy this, or at least try to stop the litigation. At the end of the day, it's in no one's interest, not the band members' interest, or not the people who should be band members' interest, for the nation to keep spending band funds fighting litigation that it keeps losing. So I certainly agree with you that there should be some role of Canada. What that role is, I don't know. It's obviously important for First Nations to have self-governance, and Peters has, of course, taken that route. But where that self-governance breaks down, I do think there is a role for Canada to step in.
We talked about earlier, what are those punitive damages against the council members?
Yeah, so in the breach of fiduciary duty case, the punitive damages was $50,000 against the longest serving member of council. She was on council since the 80s. $25,000 for the chief, who's has been chief since the mid 2000s, and then $10,000 against the shortest serving member of council, who was on council for 3 terms.
Wow, maybe that will put a stop to some of this.
Yeah, certainly that's the hope, is that it serves as a deterrence and serves to change the way in which Peters Nation is governed in the future.
Okay, Miigwech, thank you for this.
Thank you.
Don't go away. We'll be right back with a new study on low-risk carbon initiatives. Honey, welcome back. Members of the First Nations Climate Initiative are part of the Canadian delegation at COP28 in Dubai. The initiative calls itself an Indigenous-led forum that is fighting climate change, while at the same time developing economic activities in what it calls clean energy. Earlier this week, it released a study, Western Canadian Gas Exports, Opportunities and Risks in a Low-Carbon World. Alex Grabowski is the facilitator of the initiative. He joins us now. Welcome to Nation, Alex.
Thank you very much. Pleasure to be here.
Can you give us a brief idea of what the report says and what are some of the challenges for the industry?
Sure. The report, the purpose of the report was to identify realistic pathways for decarbonization for Western Canadian LNG. And the team did that. Dr. Johnson did that, identified different ways in which Western Canadian LNG can contribute to decarbonization efforts in various Asian countries. And so it went beyond what we're familiar with in the debate around LNG in Canada, in terms of, does it displace coal or does it not displace coal? And it looked much deeper into the various decarbonization plans of different Asian countries, identifying South Korea and Japan as, probably the most promising candidates for us to work with to ensure that Western Canadian LNG actually does contribute to the decarbonization efforts of those countries.
And where do you see First Nations fitting into this?
Well, two of the nations that lead the First Nations Climate Initiative they own LNG projects, and one of the reasons that they started the First Nations Climate Initiative was to identify if and how LNG could be part of the solution to climate change. And we've spent quite a few years now analyzing that question and a whole bunch of other questions that are related, and identified now the ways in which it can be produced at net zero in Canada and then exported. And this particular project is about identifying the ways in which it can be utilized in Asian countries to help them decarbonize. And the second phase of the project is to actually activate some of those pathways. in collaboration with representatives of those countries. And so the leaders of the Haisla and the Niska are very concerned about how they can develop these projects in a way that does help to mitigate climate change while alleviating poverty and achieving economic self-determination in their own communities.
How essential is it to the industry to complete the Coastal GasLine pipeline?
I would say it's very essential. It's almost complete now, and both the projects that the Haisla are involved in, the LNG Canada project, and then their own project, Cedar LNG, depend upon that pipeline. They couldn't have those projects without that pipeline.
As you know, there's some First Nations and others against the completion of this pipeline. What do you say to those who say it isn't a viable plan?
I'm not sure what you mean by, or what they mean by viability. From an economic perspective, it's definitely a viable pipeline. It's going to be contributing to the production of LNG in Haisla territory through LNG Canada and Cedar, and they wouldn't be proceeding with those projects if it wasn't viable. And the work that we're doing is focused on ensuring that it does contribute to decarbonization efforts, both at home as well as overseas. But that doesn't, eliminate or eclipse the tensions that have existed around that pipeline amongst different nations, and recognize that those are there, and not everyone agrees all the time. And unfortunately, we have a situation where some of the representatives of some of the nations aren't in support.
What is the message First Nations are going to bring to COP28 on the natural gas industry?
Well, the message we're going to bring is the message that this recent report has provided to us. One of the things we were quite careful about in the report was to preserve the independence of the team, who are based in primarily Columbia University, but they're an international team. And we wanted them to, and what your viewers will see if they read the report, which is available, it wasn't about whether or not we should produce any more LNG or not. It's about the LNG that we're producing, and perhaps if we produce more, how can it contribute to decarbonization? And so that's one of the messages that we're taking to COP.
Okay, miigwech. That's all the questions I have. Thank you for joining us.
You're most welcome. Thanks for having me. I appreciate it.
That's it for this week's Nation to Nation. And if you missed any part of tonight's show, you can check out our podcast. Go to aptnnews.ca/podcast. Miigwech, and have a good night.